This judge decides he has greater authority than the president in this matter of foreign policy and national security. So he issued that TRO. By the time he issued the written TRO, the planes were already in flight. And these complainants complained. They said, Your Honor, there's a bunch of TDA guys en route to El Salvador on planes now. And you know what the judge said? He told the Trump White House to turn those planes around. Turn those planes around. Do they have enough fuel to turn around? Doesn't matter. Folks, this is why our founders gave national security and foreign policy authority to the Article 2 executive branch of government embodied in a president, a single individual. Because the judicial branch and the legislative branch are not well suited to making these kinds of time-critical decisions. They're slow. The Article 1 legislative branch is supposed to deliberate and argue and debate about how laws should be structured. It takes months or years to create a law and get it passed. It just takes time. That's a process for which time is worthy. The Article 3 judicial branch is supposed to settle disputes before it. That takes witnesses and testimony and application of the law and argument. That's why civil litigation often takes years in federal court. What neither of those branches are good at is making quick decisions with a single voice, which is what the executive branch president can do as one individual, uniquely one individual. The other branches of government are not put in charge of one individual. Congress is hundreds of people. The Article 3 judicial branch is hundreds of judges, but the Article 2 executive branch is one person, a president, and then whomever he delegates. If you're ever compelled to use force in defense of yourself or your family, the good news is that if you defended lawfully, you can be very hard to convict. But did you defend lawfully? Because if you don't know where the actual legal boundaries for self-defense are, it's the easiest thing in the world to innocently step over them, and now you're extremely easy to convict. Good news. In just a single day, you can become an expert on the law of self-defense and make yourself extremely hard to convict. On Saturday, April 26th, I'm holding one of my only twice-a-year full-day Law of Self-Defense advanced classes. This class is taught live by me and live streamed to you. It teaches you everything you need to know in one day, and there's plenty of opportunity for personal Q&A with me as well. Even more good news, when you register today, you save yourself 50% off the standard registration, but that discount ends soon. Your 50% discount and many more details on this advanced class are available just by pointing your browser to lawofselfdefense.com/advanced today. And I'll also drop that link in the description. I look forward to seeing all of you there. Started on March 15th with the complaint against the Trump administration. This is the same day that President Trump issued his proclamation under the Alien Enemies Act. This is the complaint. The plaintiffs were all allowed to be anonymous. March 15th, same day. You think someone got a tip-off this was happening? You think this was politically arranged? And we have reason to believe that Judge James Boasberg specifically positioned himself to make sure he caught this case, rather than it being randomly assigned to a judge, which is what's supposed to happen to prevent judge shopping, especially in politically charged cases. So it starts on the 15th. Look at all these proceedings that all happened that same day. Notice after order, after order, after notice, after hearing, after scheduling, we're still on the 15th. Error, notice, entry, order. We're still on the 15th. All the way. None of this is happening, by the way, with anybody from the Trump administration present. That's convenient, right? Finally, we get to the next day, the 16th. But everything so far was the 15th, and this judge issued a temporary restraining order against President Trump and his efforts to deport these terrorists to El Salvador. Now, curiously, he kind of verbalized what he imagined he would put into a temporary restraining order. And he said, I'll follow up with a written order end of day. And sure enough, he issued a written order end of day. And then he complained that the aircraft packed with these TDA people was already en route to El Salvador by the time he'd written his order. That'll be a point of contention because he's claiming, well, I mentioned the order orally in court. You heard that and you sent the planes anyway. I think I'm going to hold you in contempt. So we have a whole second branch now of judicial activism by this judge attempting to hold the White House in contempt. And that's the core of what we'll be talking about today. A couple of days later, the White House gets to file a response to this, a motion to vacate. We'll take a look at that. March 17th, March 18th. Look at everything that's happening. March 19th, March 20th, 21st, 24th. This is all happening in 3 weeks, folks. This is not normal for federal court procedure. And the judge is frequently demanding that the White House turn things around, his orders, respond to his orders within 24 hours, or else. Meanwhile, of course, this is being appealed to the Court of Appeals, so they're involved on a separate track, and ultimately appealed to the Supreme Court, so they're involved on yet another track, all over this judge, who we now know for certainty, because SCOTUS ruled on it, never had jurisdiction over this case in the first place. As those of us, at least those of us who are informed on the legal issues here, knew from day one. And this is the final order issued yesterday about the contempt of court hearing Judge Boasberg intends to hold today at 3 p.m. Eastern Time to see whether, in his judgment, President Trump's White House should be held in contempt in this case by a judge who never had jurisdiction of the case in the first place. Really remarkable. Now, we had the complaint on March 15th. Magically, they were all prepared. The day the Alien Enemies Proclamation was issued by President Trump, somehow these 5 TDA members and their lawyers were ready to file a 24-page complaint in the middle of the night that Judge Boasberg caught. Nothing orchestrated there, right? Just that's how things always happen, isn't it? Absolutely not. And within 2 days, the White House had responded and raised this jurisdiction issue. This is a motion to vacate the TRO that Judge Boasberg had issued, first orally and then in writing later in the day, prohibiting President Trump from deporting any TDA members from the U.S. under the authority of the Enemy Aliens Act. Even though only 5 TDA members were actually in his courtroom, were plaintiffs to this case, Judge Boasberg decided on his own initiative to create a class of all TDA members unlawfully in America who might be subject to the Alien Enemies Act and prohibit the Article 2 executive branch president, whom we elected to exercise our political will, specifically to deport these violent terrorists from our shores. This judge decides he has greater authority than the president in this matter of foreign policy and national security. So he issued that TRO. By the time he issued the written TRO, the planes were already in flight. And these complainants complained. They said, Your Honor, there's a bunch of TDA guys en route to El Salvador on planes now. And you know what the judge said? He told the Trump White House to turn those planes around. Turn those planes around. Do they have enough fuel to turn around? Doesn't matter. Folks, this is why our founders gave national security and foreign policy authority to the Article 2 executive branch of government embodied in a president, a single individual. Because the judicial branch and the legislative branch are not well suited to making these kinds of time-critical decisions. They're slow. The Article 1 legislative branch is supposed to deliberate and argue and debate about how laws should be structured. It takes months or years to create a law and get it passed. It just takes time. That's a process for which time is worthy. The Article 3 judicial branch is supposed to settle disputes before it. That takes witnesses and testimony and application of the law and argument. That's why civil litigation often takes years in federal court. What neither of those branches are good at is making quick decisions with a single voice, which is what the executive branch president can do as one individual, uniquely one individual. The other branches of government are not put in charge of one individual. Congress is hundreds of people. The Article 3 judicial branch is hundreds of judges. But the Article 2 executive branch is one person, a president. And then whomever he delegates the executive authority that the Constitution bestows entirely in that one man, the president elected by the whole of the American people to carry out our political will. So this judge just decides he's going to micromanage this. He says, I told you not to send those planes. I want you to turn them around. And the White House said, well, we can't do that. So they just landed. And those guys got processed into CCOT, as we saw in the news. And the White House filed a motion to vacate this temporary restraining order. And the first grounds they argue is that this is the motion to vacate. 2 days later, March 17th, 2 days after the TRO, because, if you don't know it's coming, you need a couple days to prepare this kind of filing, 25-page legal argument. The primary argument here is that, Your Honor, you don't have jurisdiction over this case. So should we talk about jurisdiction? Again, what is jurisdiction? Jurisdiction refers to a court's authority over a matter before it. It's the first question every court should ask. And it's a question that can be raised at any time in a legal proceeding. Does this court even have the authority to hear the dispute before it? Because if the answer to that isn't yes, what the hell is the court doing? Nothing lawful. And jurisdiction can be limited in all kinds of ways and is limited in all kinds of ways. These unelected, black-robed, tyrannical federal district court judges do not have the limitless, infinite, universal authority that they claim to have in these cases. Their authority is limited. It's limited by the Constitution. It's limited by Congress. Congress creates these inferior trial courts. Congress tells these courts what jurisdiction, what authority they have and do not have. Now, the federal district courts are courts of general jurisdiction, but it's limited. It's limited geographically. They're only supposed to hear disputes from within their district, for example. It's limited in terms of subject matter jurisdiction. Congress routinely carves out areas of jurisdiction away from the federal district trial courts and gives it to specialty courts or gives it to specialty administrative processes. That's why we have bankruptcy courts and immigration courts and tax courts. And for payment disputes with the government under contract, we have the Court of Federal Claims. District courts don't have the jurisdiction to hear contract disputes with the government. Congress set up a specialty court for that purpose and took that jurisdiction away from the federal district trial courts. The same with employment disputes. You work for the executive branch, you feel you were wrongfully terminated, you can challenge the government on that, but you do it through the Merit Systems Protection Board, an administrative process that Congress established specifically to take these employment cases out of the jurisdiction of the federal district courts. So every time you hear one of these dozens of federal lawsuits against Trump about NGOs complaining that they're not getting paid as their contracts demand, none of those cases belong in federal district trial court. They all belong in the Court of Federal Claims. And every time you hear someone was fired by the executive branch and they go crying to a federal district court, that district court has no jurisdiction over an employment dispute within the executive branch. That jurisdiction has been removed from them and instead given to the Merit Systems Protection Board. None of these district courts hearing these wrongful termination cases have any jurisdiction over these cases. They're acting lawlessly. And that's also true with respect to the third major bucket of cases, these immigration national security cases. Congress defines what jurisdiction courts have, and Congress defines what due process you get in court. Due process is not a single homogeneous thing that applies in all circumstances. The amount of due process, the amount of rights that you have going into court varies depending on who you are, depending on the peril of the legal charges brought against you, the legal consequences you're facing. But the point is, Congress decides what due process you get. Congress, and to some extent, the Constitution. For example, the Constitution says you're charged with a felony, you get a jury trial. You have a right to counsel. And Congress adds a lot of additional due process through legislation. But it's Congress that defines the due process you're entitled to in court, and therefore, by extension, the authority of the court to apply that due process, not the courts themselves. And Congress, in the context of the Alien Enemies Act, explicitly set forth what due process was required in those cases. And it's not the due process of a typical immigration proceeding that might happen in immigration court. The Alien Enemies Act is different. It's a parallel, independent means of deporting aliens separate from the parallel immigration courts system. There's lots of due process people are entitled to in the immigration courts before they're deported. None of that applies. None of that applies if they're being deported subject to a proclamation under the Alien Enemies Act, which is how these TDA people were being deported. And what does the Alien Enemies Act say is the due process that someone being deported under the Alien Enemies Act is entitled to? They are entitled to due process. Even the White House has said from the beginning, from this argument here, that the court has no jurisdiction. They're not saying that these people being deported are not entitled to due process. Everyone is entitled to due process. Everyone recognizes that. That's never been in dispute. What is in dispute is just what due process are they entitled to. And in terms of deportation under the Alien Enemies Act, the Aliens Act tells us exactly what due process someone is entitled to. And what they are entitled to is what's called a habeas hearing, habeas corpus. We're all entitled to habeas corpus if we've been seized, detained, arrested by the government. Essentially, what habeas calls for is you've been arrested, you're being detained by the government. You can demand that you're presented in front of a judge, and the government has to explain why they're justified in detaining you. That's what a habeas hearing is. In the context of the Alien Enemies Act, someone is detained in preparation for deportation under the Alien Enemies Act. The Alien Enemies Act says they can be presented in front of a judge. And the government has to explain to the judge that the government has good reason to believe this person is legitimately subject to deportation under the Alien Enemies Act. In other words, that they fit the class of people defined by the act and the proclamation putting the act into effect. In the context of Trump's proclamation of the Alien Enemies Act, the conditions that have to be satisfied for summary deportation under the Alien Enemies Act are the government has good reason to believe this person is a member of TDA, the quasi-military Venezuelan force engaged in predatory incursion into the U.S. for violent and criminal purposes. Second, the Alien Enemies Act itself, passed by Congress, says it only applies to people 14 years of age and older. And third, President Trump has said we're not applying this to anyone who's either a U.S. citizen or a permanent resident alien, green card holder. So any of these people being deported under the Alien Enemies Act proclamation of Trump can demand to be produced in front of a federal judge, and the government has to stand up and say, Your Honor, we have good reason to believe this person's a member of TDA, that they're 14 years of age or older, and that they're not a U.S. citizen or green card holder. And as long as the government can say that, you're deported summarily under the Alien Enemies Act any place the president wants to send you, because that's what the Alien Enemies Act allows. The president determines the process for deportation, including the destination. So these five guys in front of Judge Boasberg, they also were entitled to a habeas hearing. In fact, their first complaint was a demand for habeas, to be produced in front of a federal judge, to compel the government to demonstrate it had good reason to believe they were TDA 14 years or older and not citizens or green card holders. But here's the thing. The black letter law says if you're demanding habeas, you're demanding that whoever in the government is detaining you produce you in front of a federal judge and justify the detention. You have to be produced in front of a judge in the district where you're being held, where you're being detained. You can't just go judge shopping. Whatever prison or detention center you're being held in, the federal courts in that area hear your habeas claim. No other court has the authority, has the jurisdiction to hear a habeas claim from someone not being detained within their jurisdiction. Well, these five guys were being held in Texas, a Texas detention center. So they can demand habeas. They can demand to be produced in front of a federal judge and have the government explain why it feels they can legitimately deport these people under the Alien Enemies Act, but it needs to be done in a federal court in Texas, not the District of Columbia. Now, they filed their, of course, political activist lawyers who are all housed around Washington, D.C. They don't live in Texas. They live in Northern Virginia. They didn't want to file in Texas. Texas is far away. And they don't have the kind of political connections in Texas that they might have in the district court of the District of Columbia. So they filed, not in Texas, for habeas, which would have been appropriate. They filed for habeas in D.C. And magically, coincidentally, the filing was brought into the courtroom of James Boasberg, who was happy to assert authority over this case. Now, he quickly pointed out to these lawyers that, you know what, you might not want to do a habeas motion, because if you do a habeas motion, technically, I'd have to send it back to Texas. And you don't want me to send it back to Texas. They're not going to give you the kind of favorable treatment I'm going to give you. So he helped them orchestrate a false basis for jurisdiction in his court. That's what the Supreme Court just ruled on, 5-4. And the Supreme Court said, nope, because your false basis for jurisdiction is false. The only due process these 5 people were entitled to was habeas under the Alien Enemies Act, just like I spelled it out for all of you, just like I've been saying since March 15th. The only thing they were entitled to is habeas, and the only place they could get habeas is Texas. So Judge Boasberg, in fact, you've never had jurisdiction over this case. You've never had legal authority over this matter, which would mean that every decision, every order, every restraining order, everything Judge Boasberg has done in this case has been without jurisdiction, without legal authority, and lawless. That's the kind of judges we're dealing with. The guy's been a judge for decades, by the way. It's not like this is his first time. He knows damn well what he's doing. He knows what jurisdiction means. He knows he didn't have it. And for 3 weeks now, we've been going through this entire docket that I shared with you, hundreds of entries. We've been going to the Court of Appeals in the District Circuit. We've been going to the Supreme Court, all happening in a 3-week window because of this judge's arrogance in pretending that his authority is limitless, infinite, without constraint. Absolutely terrible. And of course, everyone's been pointing out this jurisdiction issue forever, and he just ignored it. Now, Boasberg, who's very much, obviously, a respect my authority kind of judge, even though he had no authority in this case ever, he was very upset that the White House didn't turn those planes around. So he started asking for all kinds of detailed questions about the flights. What time did they take off? What time were they in international airspace? How many people were on them? Here's an example of an order from Judge Boasberg on the 20th. So just 5 days after this all went down, after the planes had landed in El Salvador and the TDA terrorists had been perp walked into the prison, had their heads shaved, all filmed for our entertainment, the judge said, yeah, White House, I want you to start explaining to me how this happened, because I told you verbally in court I didn't want this to happen. And then later I issued a written TRO. I want to know, and your responses to me are woefully insufficient. Because the lawyers in the courtroom, they don't know these details. They're not flying the damn planes. They don't know what time they took off. All they can do is assure the judge that we didn't violate your TRO. Now, here's a wrinkle. Here's the judge ordering the White House to provide answers on all this. Well, here's the wrinkle. The judge is all upset that they didn't obey his oral TRO. When he told them in court, I'm going to be issuing a TRO later that's going to look like this. And later he did, in writing, that evening, issue a written TRO. But in the meantime, the planes were gone. The planes were sent off. And the judge is saying, well, you knew I was going to issue the written TRO, so you effectively violated my written TRO by sending the planes out when you knew I didn't want you to do that. Well, here's the thing, folks. In oral TRO, one not in writing, the one he gave earlier in the day, that's legally non-existent, because the key feature of a TRO, a key requirement for it to be legitimate, is the party being restrained has to know exactly what they are allowed to do and not allowed to do. And the only way to have that degree of precision, to have everybody on the same page, is to have it in writing. An oral TRO is without effect. So there was no TRO until it was issued in writing, and the planes were sent off before that. So sending off the planes could not have violated a TRO because there was no effective TRO until later in the day, after the planes had already taken off. But the judge doesn't like that answer. He doesn't like that answer. So the court said, the White House said, Your Honor, you're asking for all kinds of detailed questions. The complainants, the TDA members in court are asking the judge to order the White House to disclose tactical details about how these flights are arranged, national security details. And the White House is saying, we're not comfortable doing that. We're not comfortable doing that. And the judge is saying, no, you're going to do that. In fact, you're going to tell me within 24 hours. And then the White House says, well, you know what, Your Honor, we feel that some of these are state secrets, and there is a privilege held by the executive branch. It's called the state secrets privilege. And under that privilege, the government, the executive branch, cannot be compelled to disclose state secrets, national security secrets in court. And the White House said, you know what, we can't address this in 24 hours like you're demanding of us, Mr. Tyrannical Judge, because we have to have internal conversations, and we have to do legal research, and we have to consider the arguments for invoking the state secrets privilege here. So they told the judge, listen, we need more time. And the judge said, you know what? I think your invocation of the state secrets privilege is BS. I have zero respect for that position, even though all the national security authority is placed in the executive branch. Another overreach of this Article 3 judge. But I'll give you another 24 hours. You have 24 more hours. Look at how gracious I am to all of you. And ultimately, of course, the White House came back and said, you know what? We are invoking the State Secrets Act. And the judge still wouldn't accept that. He started scheduling contempt hearings within days. You will appear in my court and you will explain to me why I should not hold you in contempt. Here's one of those orders from the docket, March 19th. I know it's a little hard to read. Sorry about that. Let's see. They have until March 20th at 12 p.m. to provide the information demanded by the court on March 18th, or to invoke the State Secrets Act. So he's demanding an answer by noon the next day, because this order was issued on March 19th. He's demanding the White House answer by the next day, 24 hours later, or invoke the State Secrets Doctrine, privilege, which, of course, is what the White House ultimately does do. Then he makes more demands the next day on the 20th, when the White House asks for more time. He says, well, by the next day now, March 21st, by 10 a.m., I want the White House in here submitting a sworn declaration by a person with direct involvement in the cabinet level discussions regarding invocation of the state secrets privilege. I want you to explain to me your internal executive branch discussions about asserting a privilege that's unique to the executive branch. This is outrageous overreach by this judge, an outrageous violation of the separation of powers doctrine and of executive privilege held by the White House. Then on March 31st, he's still not happy, because by then, this is a few days after the White House had asserted the state secrets privilege, he's still demanding that someone from the administration appear before him in person within a couple days to show cause why the White House, why the administration should not be held in contempt. He asserted this again. By the way, this was a hearing he ordered for April 3rd, this contempt hearing against the White House. Keep in mind that this judge never had jurisdiction in this case. Every one of these orders is unlawful because he lacks the authority to hear this matter. But this judge is still issuing these orders. And the fact that he has no jurisdiction was brought to his attention, as if he didn't already know, but it was explicitly brought to his attention by the White House 2 days after the initial complaint was filed. So they have this hearing on April 3rd, and guess what he does? You see in the little blue pocket here? Sealed on Pacer. That's the transcript. He had this show cause why President Trump's administration should not be held in contempt. He had that hearing on April 4th, and then he sealed the transcript. I can't buy it. It's sealed for 90 days. So we can't know what was said in that hearing. Then, of course, we had the SCOTUS decision yesterday, affirming what we all really knew already, that this judge never had jurisdiction over this case, ever. He never had authority over any of this. And after that was released, obviously, with the knowledge of Judge Boasberg, he knows about this decision. After that was released yesterday, he says, yeah, you know that contempt hearing that I scheduled for Tuesday, April 8th, 3 p.m. Eastern time? Despite the Supreme Court ruling that I never had jurisdiction over this case, ever, not for an instant, I'm still moving forward with that contempt hearing. I am still asserting authority over this case. That, folks, is absolutely outrageous. He knows exactly what he's doing. And if this doesn't qualify as the bad behavior that violates the Article 3, Section 1 tenure requirement for federal judges, that they hold their office only during good behavior, if this collectively is not bad behavior, I don't know what is. And allegedly, this is not the only bad behavior of this judge with respect to President Trump. I'm going to read you an article in just a moment that covers a lot more. Now, that article is not my work product. Someone else wrote it. I'll share that with you. It's an account on X. I think does good work, is worth a follow. But they have some very interesting things to say about Judge Boasberg in this case and in other cases too, so many of which, shockingly, involve actions, legal actions against President Trump, that Judge Boasberg keeps catching those cases. It's really weird. All right, I did do a poll before we started here. Let me pull this up. I asked, what's your take on Judge Boasberg's actions here, continuing with this contempt hearing, contempt of court hearing? First option is the judge is right and Trump just sucks. 2% of you chose that. The judge is simply honestly mistaken. He just didn't know. He was shocked when the Supreme Court told him he never had jurisdiction in this case. He'd never thought of this before. This is all news to him. 1%. And this judge is a political activist. 98% of you. Also did a poll on Twitter. Let's take a look at this one. Essentially the same results. The judge is right. Trump just sucks. 0.8%. The judge is simply honestly mistaken about this. He just didn't know the law on jurisdiction. He didn't know how habeas worked, despite it being laid out in front of him by the White House in their own motion to vacate 2 days after he started this chaos. The judge is simply mistaken, 2.3%. And this judge is a political activist, 97%. 97%. This is an account on X, goes by the name Amuse. See if I can make this bigger. Wrote this article on X about Judge Boasberg and the judiciary. And I just thought it was an interesting read. Now, there's factual claims in here that I don't know if they're true. I'm not an investigative journalist, but I thought all of it was, I saw much here that I know is true. And I thought it was a well-written take on Judge Boasberg and activist judges in general, so I thought we'd share it all together here. Amuse writes, by the way, he's a good follow. He's always got good content. At Amuse, if you're on X. Who watches the judges? Congress must investigate Judge Boasberg. It's a foundational tenet of the American legal system that justice must not only be done, but must be seen to be done. When that principle is imperiled, especially by those entrusted with its guardianship, it becomes the solemn duty of Congress to investigate. Recent developments surrounding the Enemy Aliens Act case filed in the U.S. District Court for the District of Columbia on March 15th, the courtroom of Judge Boasberg, raised grave concerns about judicial impartiality, procedural integrity, and the unchecked discretion of the Chief Judge James Boasberg. The facts, as they are publicly known, demand scrutiny not only because of what they suggest about one judge's conduct, but because they expose a structural vulnerability in the federal judiciary that Congress is uniquely positioned to address. To review, the case in question challenging the Trump administration deportation, use of the Alien Enemies Act, was filed between 1 and 3 a.m. on a Saturday morning. According to the District of Columbia's local court rules, such an emergency filing would by default be assigned to an emergency judge on rotation, who remains on call from 4:30 p.m. the previous day until 9 a.m. the next business day. that emergency judge is not the Chief Judge Boasberg. In fact, the rules explicitly preclude the Chief Judge from receiving emergency assignments. That's the benefit of being the Chief Judge. You're never on that nighttime rotation. Yet Chief Judge Boasberg, then vacationing outside the jurisdiction, appeared on the emergency hearing via video conference, casually attired, and by his own admission, enjoying time away from the bench. His presence in and of itself violates the assignment protocol. His assignment to this case, the Enemy Aliens Act case, under any reasonable reading of the court's established procedures, should have been impossible. It would require either a clerical error of monumental proportion or deliberate circumvention of court protocol. That seems pretty likely. Reports now circulating suggest the latter. According to sources referenced by Senator Eric Schmidt in public statements on April 6th and 7th, Judge Boasberg was aware of the impending emergency filing and alerted the clerk of court, Angela Caesar, with instructions that the case be routed to him rather than to the designated emergency judge. Now, how would he have been aware? The proclamation by Trump was only made that day, March 15th. So how would anybody know to challenge the proclamation before the proclamation was made? Well, of course, because there's rats inside the executive branch acting contrary to the will of the Article 2 executive branch President Trump that leaked this information. How else would these lawyers have had a 25-page complaint ready to go instantly when the proclamation was released by Trump? And this judge knew to position himself to catch this case rather than have it randomly assigned to whoever was the emergency judge that evening. If true, this constitutes an egregious abuse of authority. It would mean that the chief judge, a role explicitly exempted from emergency case assignment, not only inserted himself into a high-profile case, but did so while on vacation against procedural norms and in a manner with obvious political implications. Even more disconcerting is that this is not an isolated incident. The Enemy Aliens Act case marks at least the fourth major case involving President Trump to land in Judge Boasberg's courtroom. Statistically, the odds of such a pattern arising purely through random assignment are vanishingly small. When coincidence becomes regularity, suspicion becomes reason. Now, I will put in 2 cents about this. So the assignment of cases to judges is not literally random. Now, there are 11 District of Columbia district trial court judges, 11 of them. I think the breakdown is like 7 liberals, 4 conservatives. But the way cases are assigned is not purely random. It's an algorithm that takes into account a judge's current caseload and other factors, upcoming vacation. So it's not purely statistically random. Was there something else I was going to say here? Oh, he says 4 cases. So 2 of those cases are contemporaneous right now. One is the Alien Enemies case. The other is the brand new Signal Gate case, where members of the cabinet were using the Signals Chat Act to discuss bombing the Houthis, and that got exposed. Now, one of the lawyers who spent his whole career doing nothing but attacking Trump, Norman Eisen, has filed a lawsuit against the government for using an encrypted chat signal, claiming that they're doing it to avoid having to properly disclose government communications. It's all nonsense. Government officials in the Biden administration were using the Signal app for years. It was pre-installed on the government phones that the Trump cabinet received. It's just another nuisance lawfare suit against the Trump administration by Norman Eisen. And it landed in Judge Boasberg's courtroom. So Judge Boasberg is handling the Signalgate case too. There are 2 other cases, not of today, but involved Trump, and it was a big deal. One of them was the Trump Russian collusion search warrants, spy warrants that were issued against Trump in his first administration based on falsified emails and affidavits. It was all nonsense, of course, we know today. But this judge issued those warrants. Maybe he wouldn't have issued the warrants on falsified information. Maybe he would have looked at the purported evidence more closely were he not anti-Trump. I guess we'll never know. And then when it was exposed to the judge that one of the FBI lawyers who presented email evidence in support of the warrant had fabricated that evidence and he confessed to this. It was a crime. He took a plea bargain to fabricating the evidence that led to the judge issuing the spy warrant against Trump. That lawyer who lied to the court and got the court to do something unlawful. The court would argue they didn't know it was unlawful, but it was not a lawful spy warrant. It was based on falsified evidence. When that person, as a criminal defendant, was brought before Judge Boasberg, the very judge he'd lied to, how do you think judges normally react when they discover lawyers are lying to them? Not well, because judges are expecting, it's a rule of conduct for lawyers, that they have an obligation of truthfulness to the court. Otherwise, the judge has to question everything that comes out of a lawyer's mouth. So the presumption and the ethical duty of a lawyer is to not lie to the court. So if you're caught lying to the court, and this is what the court relies on, not to have to investigate every claim of every lawyer in their courtroom, it's a big deal. It's a really big deal. I would expect a maximum sentence from a judge I'd lied to in a criminal fashion. But when this defendant, I think it was Carter Page, came before this judge, having confessed to lying to the judge to get the spy warrant against Trump, this Judge Boasberg sentenced him to 0 prison time, although he was facing substantial prison time, just a few months of probation. So makes one wonder. The article continues. The potential for conflict of interest with Judge Boasberg compounds the concern. Boasberg's daughter, Catherine Boasberg, is employed by Partners for Justice, a nonprofit that offers legal support to undocumented immigrants, including those affiliated with violent criminal organizations like TDA, subject to the Alien Enemies Act, case in which this judge was ruling and issuing orders in the absence of legal authority to do so, without jurisdiction. The nonprofit's founder has praised Judge Boasberg's ruling against the Trump administration's deportation efforts and has publicly opposed legislation such as the Laken-Riley Act. Laken-Riley, of course, having been a tragic victim of the violence of these illegal migrant gangs. The Laken-Riley Act designed to enhance the detention of certain undocumented aliens. While familial relationships alone do not prove bias, they do create the appearance of partiality, which is precisely what judicial ethics rules aim to avoid. Yes, the code of conduct for U.S. judges requires that judges avoid even the mere appearance of impropriety. Further undermining public confidence in the judiciary is Judge Boasberg's role in past controversies involving the surveillance of the Trump campaign. As presiding judge of the Foreign Intelligence Surveillance Court, he oversaw a body that authorized multiple surveillance warrants as part of the FBI's Crossfire Hurricane investigation. That process, later condemned by the Department of Justice Inspector General for significant inaccuracies and omissions, has long been a source of conservative critique. For Boasberg to reappear again and again in cases involving Trump not only strains the limits of procedural plausibility, but raises questions about institutional trust. There is a deeper philosophical question here, one that cannot be resolved by mere appeals to procedural irregularity. That question concerns the legitimacy of judicial discretion in a democratic system. If a judge can, by informal conversation with the clerk, override the court's assignment rules, then the principle of random case assignment becomes a fiction. And the reason we have supposedly random case assignment is to avoid judge shopping or judges grabbing cases of political interest to them. And if the fiction is permitted to persist that it is random, then the judiciary itself risks becoming a partisan actor, cloaked in the illusion of neutrality. Skeptics may object that judicial independence demands restraint from legislative interference, but this misunderstands the nature of the concern. What is at issue is not judicial decision-making per se, but judicial self-dealing. The quiet assumption taking on of cases where personal or ideological entanglements create even the appearance of bias. Congress has a constitutional role to play in ensuring the separation of powers does not devolve into collusion among the elite, shielded from political accountability. And the Article 3 judicial branch is the least politically accountable branch of government. Continuing, this is not a call for punitive action, it is a call for transparency. Congress must investigate the assignment of the Alien Enemies Act demand records from the clerk's office, and compel testimony where necessary. It must examine how often chief judges nationwide are assigned to emergency matters and whether there exists a pattern of assignment manipulation in politically sensitive cases. Moreover, Congress should consider legislation mandating the strict enforcement of random judicial assignments, particularly in high-profile or politically sensitive litigation. The model might borrow from the securities litigation context, where judges are barred from steering cases or influencing assignments in any way. Digital assignment logs, subject to audit, could serve as a check against manipulation. Further, judges with known familial or organizational ties to parties or causes implicated in a case should be required to disclose those ties and recuse themselves where appropriate. No judge, however distinguished, is above the law. No procedural convenience justifies the erosion of public trust, and no institutional prerogative outweighs the need for impartial adjudication in a constitutional republic. Judge Boasberg may yet have an explanation that satisfies procedural and ethical scrutiny, but it should not be his burden alone to offer one. It is the responsibility of Congress, as the people's branch, to ensure that the judiciary does not become an instrument of selective justice. When the rule of law begins to resemble the rule of preference, the moral architecture of the republic begins to crack. We are not yet at the precipice, but we are near enough to hear the echoes from the abyss. It is time to act.